Thank you again, Joanna, and all the conference committee for inviting me to this conference. I hope you are enjoying your afternoon, and I hope not to destroy it, because I'm going to talk about the law. The law, you love or you hate it. There is no compromise, or there should be. I'm going to talk about copyright law in particular. In the art world, it's not the only area of the law that matters, because tax law is a very important area of the law in art, but also personal information law, and also other IPRs, for instance, trademark. Some of you might be an expert in trademark, so jump on the discussion if you have something to say about it. I will focus again on copyright mainly. I will choose some images to visualize better the concept that I'm gonna discuss. And this, the big wave, the great wave, I think it's very symbolic of the relationship between art and law. I really believe that art is hardly framed by the law, but lawyers do not sometimes care about it because they just apply their principle without thinking that maybe this principle should be reconsidered or interpreted in a different way. From the art perspective, from the art experts in particular, law sometimes is desirable, sometimes is not, depending on really your interest in the copyright work. Some thoughts on art law, I think, are very important. As you see, it's all mixed up, but it's okay. It is meant to be. Let's say that. Copyright law has some fundamental principles that we need to remember. I need to remind you. And these principles do not really work very well in the post-digital world. And we'll see why this is not going to work. A very important premise we need to make about copyright is that copyright has some international ground, but it's mainly territorial. So we really need to focus on the jurisdiction we have in mind to really understand how copyright works. Even in the EU, we might think that European copyright is all unified, applies the same way in all the member states. Is not. Well, most of you already know that European copyright law was supposed to be harmonized, and this harmonization should also be not based only on statutory law, but also on the judiciary activity, but indeed is not really harmonized. It is highly fragmented. One example of this is the topic of exceptions. You were mentioning the copyright exception, particularly one referred to text and data mining. Well, we shall see how the new directive is going to be implemented in the different member states, and we shall see if this fragmentation is going to last, or we expect something better from member states. At this point, given that we need to think about the national transposition of the earlier directive, the InfoSoc, then we can say for sure that it's fragmented and there is really a lot of uncertainty looking at the different member states, how they apply the law. What about this picture? These pictures, for me, represent the desire of the law to protect something that maybe is not really desirable to be protected. So, do we really want to protect the unprotectable? How do you measure what the copyright should protect or not? Do you have a clue? How many of you have some knowledge about copyright and know how copyright work, like the basics of copyright? Some of you, yeah, not many. So those of you who know, or certainly know that copyright only protects original works of authorship, right? And copyright does not protect ideas. Copyright does not protect raw data, does not protect facts. But how comes that we are trying to protect something else now? Like, don't you have the impression that, as the title of my presentation say, we are not looking at artworks anymore, so we are not looking at works anymore, but rather data, and sometimes raw data that copyright is not supposed to protect? Have you ever asked yourself any of this question? Maybe you will. So one of the principles we're saying is that copyright does not protect the idea. But this principle has to be complemented by the specification that only original works are protected. What is original? Do you think that the law has a clear idea of what is original? Do you think that courts know what's original? And still they are deciding that, because when you bring a claim before the court and you allege that someone has infringed your right in your work, then the court must assess whether the work is original or not. Typically, in every jurisdiction, at least now I'm thinking about my own system, but this applies to many other systems. When you go before the court and you ask to prove that someone has infringed your right, you need to prove that you own an original work. So how do you establish what is original and so what is worth protecting? The court sometimes relies on expertise, so the help of expert witness might be of help, but it's not really the final word, should not be the final word of the judge. So the question might be, is there a definition of originality in our laws? No, there's not. So our law, the copyright says that only original works of authorship, and in your case of art, must be protected, but doesn't really say how original this should be. The statutory law list. What matters is that courts, the judiciary, is doing something to, let's say, find a compromise solution about that, because the court, the judiciary is providing some elements, some standards, some criteria to be used to determine what's original or not. The Court of Justice defined originality in terms of an author's own intellectual creation. Do you find it useful? Do you find this to be the answer to your question, how you should define what's original or not? It's difficult. It's difficult for courts, for national courts also. And sometimes, even if the Court of Justice is very strict in this and says that, always underlines, even in very recent case law, that the work is original when it's the author's intellectual creation, national courts are not really always at ease with this definition. And this creates a lot of uncertainty, as you may imagine. What about this image? All of you know this, right? Do you all believe that this is a work of art? From the perspective of art historians, of our experts, is it a work of art? Yes? Who thinks it's not? Nobody. So all of you think it's a work of art. But actually, the US Custom Court back in the 1927-28 did not think so. In fact, this is a very interesting case, an historical case, for not only for US law, but also for the art world law in the art law world in general. Because even if it was a tax case, because Brancusi, the artist, together with Duchamp, went to New York to exhibit the work of the former, was stopped at the custom because the custom office believed that was not a work of art. It was just a kitchen utensil. So for being a kitchen utensil must be subject to the custom law, so must pay a fee. So from being just a tax law case, it became a landmark case in arts law because it really suggests questions that are not only legal questions about what has to be considered a work of art, which means what is a work of art that is protectable by copyright? What is the role of expertise in that? What is the role of the artist? For instance, How relevant is the fact that the author believes this is a artwork? How relevant is that experts think this is a work of art? All of these questions might be not new for you, for art historian, for art experts, but they are new for the law. Even if it already addresses these questions back in the 1928 or even earlier. But still, our judges are confronting with these questions. And the more the art evolves, the more technology evolves, then the harder it is for the judiciary to decide what is art, what is worth protecting, what are the rights including, and so on. This is another exemplary case I bring from the US case law. Have you ever heard of the Philip saga? Anybody knows about this? Well, it's an interesting case because at first the artist was considered to have all the rights to oppose the disposition of his work. This statue could not be moved from the place where they were exhibited. But then the court changed its mind because it thought that this is actually site-specific art. And site-specific art is not like other art. It's not like fine art. So the judiciary wasn't really sure whether this could be subject to copyright protection. And indeed, in the end, decided not to be protected by copyright because, and I just need to add this specification, in US law protects visual arts also, not only with the Copyright Act, but also with the VARA, Visual Artists Rights Act. If any of you know about it, it's an act of 1990, and recognize moral rights as well to artists. It's a peculiarity of the US system, because compared to European jurisdiction, where in most countries moral rights are recognized, like economic rights, in the US this application of moral rights is very limited. It not only regards only visual arts, but it also has lots of restriction. Just to make the picture more complete for your knowledge. Beyond the principle I already told you about in copyright, we must remember, and the Philip saga helped me in this, that copyright not only comprises economic rights, but also moral rights. So these are just two aspects of moral rights, or droit d'auteur, as we should always, as I was discussing with the moderator earlier, use not only the word copyright, but also the most appropriate term we use in our own jurisdiction. If we use in general terms copyright to apply to any country, then it's correct to do so. But if we refer to a specific jurisdiction, we must be more accurate and more precise, using also the wording that our own legislation uses. For instance, in Italy it would be diritto d'autore, and in France, droit d'auteur. Actually, if you just want to find two of them to make it easier, then you should use the French wording, just to clarify that there are two different positions in the legal system. Word. So the common law countries would rather talk about copyright. The civil law countries would rather more precisely talk about droit d'auteur. I already say that the Court of Justice really underlines this aspect that only original works of art, I say art now because we're talking about art, but original works of authorship are protected. No formality is really required, and this comes from the Berne Convention, a very important international document we should always bear in mind. But still, formality sometimes helps, especially from a procedural point of view. Sometimes you might need, as a plaintiff, to demonstrate the ownership of your work, and the deposit or registration actually help. There's a long discussion in legal scholarship about the scope of what are in truth formalities that are used in different jurisdictions that shouldn't be there because Berne doesn't allow that, but still they are. I don't want to bore you with this, but I think it's an interesting issue that probably some of you already encountered or might be encountering in the future. About the length of copyright, everybody knows that is at least 50. Well, some countries, if we look at it broadly, consider different terms, but on average, it's at least 50 years post-mortem auctoris, or more frequently 70 years post-mortem auctoris. What does it mean? That only after the passage of this period, then the work will be out of copyright. And so there won't be any more exclusivity in terms only of economic rights. What do I mean by that? If I say that copyright comprises both the moral and economic rights, in the jurisdiction, like the ones where I work in Italy, moral rights will actually last forever. And same is with most of the continental countries. So there is no really duration for moral rights in some countries, those who really apply strongly moral rights. This means that even if you believe there is no rights any longer in the work, you might be infringing the moral rights of the author. And these rights often can be exercised by the heirs, which makes a nightmare for museum workers, right? I have some experience with that, especially when heirs allege that the right of integrity has been infringed. That really is a nightmare, because you can say anything to claim that your right of integrity has been infringed because it put some prejudice on the reputation of the owner of the artist. This is important I thought this was important to say, because we don't always think about this double coin of copyright. We sometimes just focus on the economic aspects, which, of course, it's perhaps the most relevant aspect in our society, but still moral rights are also to be considered very, very important, especially in the art world. The owner of the copyright enjoys exclusivity. What does it mean? This certainly connects to some of the speeches that were made earlier and were made yesterday. This strong exclusivity prevents others to do anything with the work if the owner has not given permission. So the basic principle that you should always remember is that unless I don't have a permission or authorization, I cannot perform any activity unless an exception applies. So in case the exception applies, then I'm more comfortable, right, performing some certain activities. If no exception applies, then I must be careful. If there is still exclusivity in the work and I don't have a permission to do that, then I will most likely infringe the rights. And this, and I think it's important to specify this aspect, means that even if we have perhaps authorization to perform a certain act, we don't have the same authorization to perform other acts. Let me make you an example. I have a license to reproduce a work of art, and everything is fine if I reproduce that, but I don't have in the same license the right, I wasn't given the right to, for instance, modify the work. If I do, and the license does not tell me explicitly that I can modify the work, then I'm infringing the rights. This might be more complicated when I need to understand in the post-digital world what is reproduction. In fact, I'm glad that you mentioned my previous work with text and data mining, but there we had to focus a lot on determining what is reproduction for a non-lawyer, especially those who work in the natural language processing. They have a different idea about what is reproduction. open compared to what is reproduction for the law. For the law, reproduction means anything, like no length at all. Even 11 words, according to the Court of Justice, are a reproduction of the work. So we must approach the matter really with the more cautiousness, remembering that, as I gave at the very beginning of my presentation, we use different instruments, lawyers and non-lawyers, we apply different principles in art and in law, but we are almost we are obliged to merge them when the judiciary is asked to solve a dispute that concerned artwork. So we must find a compromise, otherwise we should say that the law shouldn't care at all about art. But is it what we really want? Because yesterday I was hearing about different approaches of museum being very reluctant to allow any use, so they must be concerned, they must be interested in some kind of protection. So yes, openness, as the previous speaker said, but openness with some judgment is probably what we are looking at. I wanted to bring some more case law to your attention because first, they are more fascinating than talking just about statutory law, and also they are more into the reality of art. I don't know if you ever heard about this case. Perhaps if some Italian are within the audience, they might, but it's an interesting one. It's only in Italian. The limit of our judgments is that they are mainly available in Italian. No translation is provided. You can use tools, of course, to translate. So please have a look if you're interested in the subject of copyright in Italy. But this case I think it's emblematic because it portrays the tension that there's in the attempt of the law to really regulate art. The picture on the top, on the left, is a picture that represents the photography. So it's a photographic work, an artistic work. I want to specify this because depending on the jurisdiction, as I said, some countries, even in Europe, might acknowledge protection for only for photographic works that are original, in a sense that I previously said, but in some jurisdiction there could be some kind of protection, like more limited in terms of time and other restriction, for photos that are just photos. So for instance, photos that reproduce artworks. These are considered mere photos, simple photos that still receive some kind of protection in terms of neighboring rights, but they are not the same as photographic work. So this distinction said, in this case, we have a photographic work, which is fully protected. And the photographer claimed that the painter on the right, so images on the right, Muscio, reproduced his work in an oil of canvas. So we have two different media here, a photography and an oil of canvas, a photographer and a painter. Well, perhaps some of you might have noticed that the name of the works is the same. And this was an issue brought before the court by the claimant, saying that, well, he clearly infringed my economic right because he made a reproduction with an authorization, but he also infringed my moral rights because he did not mention me as the author. So it's like, in tort law, more like a passing off or reverse passing off. So you are not acknowledging my authorship, so you are really infringing the core of my rights, not only economic, as you reproduce with no authorization, but also moral, the moral rights of paternity. Who do you think won? Just a clue. Any clue? The photographer, of course. He won because the court was really convinced by the claimant that this was a clear reproduction, clear violation of the former work, and did not really care about the canon of imitation. So, as you know, in art history, imitating is essential, because without imitation, you don't develop. Not only to develop, but also to critique, to produce more knowledge, to advance in art. So this case is an example of how the law is not really paying attention to the artistic principle. Just apply its principle, its own principle, without really caring about it. What about this canon of imitation? Where did it go? Do you think it's still surviving somehow in this picture of a copyright that just want to protect anything, even what's not protectable? Where did it go? Is it going anywhere? Is it reviving anywhere? It might. It might through copyright exceptions, depending on how the member states are implementing them. It might, perhaps even more, through the fair use doctrine, the US fair use doctrine, which is an open-ended norm that really is more flexible. It's more likely to allow this sort of a revival of the canon of imitation, rather than very strict and precise exceptions that we have in Europe. You know Kunst, of course. Do you also know about his lawsuits? So many. He was a defendant in lots of cases in the US, and not only, he was also a plaintiff in one. Paradoxically, he also brought someone else before the court, but usually he is brought. Someone is regularly bringing him before the court because he has allegedly infringed someone else's rights. In this case, which is also another landmark case, the court was persuaded that it did not really provide any parody of the work, but that was just a parody of the society that couldn't be framed within the doctrine of US fair use. So that was a bad outcome for Kunst. A better outcome was in Blanche versus Kunst. I don't have a picture of that, but just to think about the Gucci sandals you might have heard about or read about. In that Gucci sandals, he was actually successful to demonstrate that he provided a parody, a criticism of that particular work, not only of society. I don't want to go into deeper details about fair use doctrine, but just to think about this as an instrument to make this canon of imitation, but also other important principles in art reviving, rather than following the stricter rule of the law. And what about going back to what we said about photograph? I decided to put this input here again. Are we persuaded that any photograph should be protected? What did the Italian court decide in this case? How did they establish originality, which, again, as I said at the very beginning, is very crucial? Any clue on how they determined that that was an original photograph? You don't need too much to demonstrate something is original, but with photograph, historical did not receive the same attention by the law in terms of protection. Most recently, this is very highlighted by the Court of Justice, you must show some degree of freedom in the choices you make. For instance, if you choose a particular perspective, you choose certain lights and not others. So anytime you are free to make choices from the artistic point of view, then you're gonna succeed much better in your claim of originality. But what happens if you have to rely on technologies that really constrain this freedom? Is it something that might make the court decide in a different way? Yes. In fact, if there is a technology that really limits, confine your creative freedom, then you are less likely to be a winner in court, because then technology is making most of that decision, and there is no freedom left for you to say that despite the use of technology, you are still putting some creative input in the work. So should we blame it on technology? Is all bad technology? From the perspective of a copyright lawyer, technology is always a double-edged sword. It means that can helps you to, let's say, follow the law, to protect the work, but it also helps you to infringe the rights. So it always have to be considered from this double and often ambiguous perspective. But what about what we were saying about concerning the fact that if you use certain technologies and you are not free anymore, then you are not producing a creative work? Are we all persuaded by that? And what about technologies like algorithms, or are there technologies that are allowing us to produce artworks in a different way compared to the past? Is there anything there that should be considered? I mean, if we use certain technology to produce an algorithm to produce a new Rembrandt, let's go forward for a moment. Here, how do you say it's possible to demonstrate that you are adding something more, that you are really providing that particular author intellectual creation? It's difficult, isn't it? It's very difficult. And lawyers, when they face this problem, this challenge of determining who is the author of an AI work, are always very uncertain with regard to the answer to this question. Because they might provide different explanation, different justification, different doctrines, like the work of Ayer, but still they are very, very uncertain with regard to the final answer of that. But what about what is even brought forward by the technology? So we are not talking anymore about producing a work, but still is produced through the help of technology. But now we are talking about data that are extracted, that are obtained, created through works that possibly do not exist any longer. Are we still interested in protecting with copyright these works or not? Are we more interested in making them available, interoperable, reusable? But why are we, or some of us, are so reluctant, for instance, to disseminate, to distribute works under less restrictive licenses? And this is what I wanted to imply earlier. Are we sure that we want just openness with no regulation, or we want openness with some judgment, and we are more reluctant to give it away once we have done a lot of work with this? It's a question that all lawyers ask. But I'm done. Luckily you. I'm done because there's no really clear answer. There's no end to this discussion in law. And you'll see, especially when the new directive that intervenes after the InfoSoc of 2001, finally in 2019, we had a wonderful, for some, scary for others, a new directive on the digital single market. We shall see how member states will really transpose into their national legislation, and see if there is really to praise for, like most institutions are praising, because there seems to be more length of freedom in terms of preserving, reproducing, doing more with the collection that we have. But still, we need to wait until the member states implement this directive. Thank you.